it is being recorded, so there you go. And I feel very excited about today's session. We are presenting In Seek of Privacy. This is a fireside chat with the author of the book, Seek and Hide, Amy Gajda, with the Tulane Law School. So Amy, hello.
Hi, thanks to everybody for joining today.
And then also brought on my colleague from King and Spalding, Misty Peterson, counsel with the Data Privacy Group in our Atlanta office. If you want to say hello real quick.
Yes, hi. Thank you so much for having me. I'm happy to be here today.
Okay, so I just want to, start this with a quick introduction of what, brought this session together. And I saw Professor Gajda's book being announced by Tulane Law School, which is my alma mater, on LinkedIn. And I had to get it and read it because it sounded very interesting. Her book, Seek and Hide, is about the history of data privacy laws in the US. And I think Hamilton did a really good job of making us all interested in, the real life foibles of our founding fathers. And Professor Gajda's book did not disappoint at the very least. So Professor Gajda does not have a LinkedIn account. And I went and found her Tulane Law address and just reached out to her, a complete stranger, and said, Professor Gajda, I'm a Tulane Law alum. Look, very interested in your book. Love it. Would you be willing to speak with our affiliate? And she responded right away to a perfect stranger. So I appreciate that very much.
I was delighted to hear from you, of course, and I'll just explain very quickly that the reason why I don't have a LinkedIn account is because I've been teaching privacy now for about 25 years. And so when social media started, I was very up on privacy. And so I think on the one hand, it's a really bad thing not to be on social media. On the other hand, it's been sort of an interesting ride, especially with regard to the book and talking about those issues.
Well, and it shows that you can still be reached. I mean, your work email is still available and you respond to it. So, we can still communicate in this age without social media. It's a good point to prove. But Professor Gajda's book was released last year, and it was highlighted by New York Times. Yes, the book. I have it too. Here.
That's so nice. Thank you.
And it was touted and selected for New York Times, top 100 books to read that year. And the U.S. Court of Appeals for the Seventh Circuit chose it as its inaugural one port, one book, like must-read book. It's excellent. If you don't have time to read, but you're into audiobooks, Danielle, who helped us coordinate this session, she let us know she listened to the audiobook, which is voiced over by Amy. So, I always I don't always listen to audiobooks, but when they're off, they're voiceover by the author, I think it's even more interesting. So I may have to go get that and listen to it and just see if did you add any extra tidbits or anything, or did you stick straight to the text of the book?
No, it was interesting. I mean, they had me read exactly from the book. And so even if I accidentally changed a word, I would have to go back in and re-record. So yeah, it was really super interesting. I think because of copyright issues.
That makes sense. That makes sense.
You have to read the endnotes as well. It seems like that'd be difficult.
Yeah, I didn't have to read the endnote.
Okay.
No. So you're right. I mean, I had that question as well. And the endnotes, there's a lot of really good stuff in the endnotes. So it was a little bit sad I didn't have to read it, but I didn't have to.
Well, and Amy, Professor Gajda, her history is very interesting. She is an attorney, but she started as a journalist first. And that background, served her well in that she is often cited in articles out there. Her bio is great. Go find her, bio on the law firm website. Great info there. So thank you very much, Professor Gajda. So glad, Amy, that you could join us. And again, love supporting, my law school, Tulane. But then Misty is my colleague at King and Spalding. She's with the data privacy and class action practice groups within the firm. She's one of the first attorneys I worked with when I started working at the firm. So she'll always hold a special place in my heart. And Misty went to law school and got her undergraduate studies at University of Georgia, which I believe just recently, maybe really beat a Texas-based university, which I think we'll leave it there. So, which is in my home, which is where I live now in Fort Worth. So with that, let's get started. And this is more of a fireside chat. So it's not going to be super formal. We don't have a presentation. We're just going to talk through it and really follow the flow of the book, which is largely chronological. We're going to start with the founding fathers and, you know, some of those early leaders within the legal community in the US and SCOTUS. And then we're going to move on to the 1900s, which, I mean, that seems so old now, but, you know, I was born in the 1900s, so it's not really that long ago, really not that long ago, folks. And then we're going to move on to, you know, more present issues. So we have questions that are prepared, but we don't have to move along at a certain pace. If we find some nugget of conversation that's really interesting, we're going to, you know, drill into it and talk about it. And of course, you know, this is all educational, not legal advice. We're not speaking on behalf of the law firm or our universities. So, you know, just wanted to lay that out there right now. But I just want to say again, if you have questions, please drop a question into the Q&A box or the chat box. Danielle's going to do a great job of keeping an eye on that and raising those questions to us so we can talk about it in real time as we're kind of having those conversations. So, all right, let's get started talking about Seek and Hide. So I found one thing I love about books is like the really small little nuggets of trivia information. And one thing that I really liked, I read a lot of books, you know, like I'm a huge Jane Austen fan. So, you know, any book that would have an article or a news clipping and it would have M dash, I think Dickens did the same thing. I always just thought it was just something that was going on with the author, just not wanting to come up with a name. But because of your book, I found out that actually in England, which of course had some major impact to US laws, a publisher could get into legal trouble if they publish something about an individual, even if it's true. So that was one little nugget I found very interesting, but those are spread all throughout the book. So it's obvious you spent a lot of time researching things for this book. So, you know, Amy, was there something that you were yourself surprised about when you were going through the research? And can you share that with us?
Sure. There are two examples coming to mind. And one was a discussion that the founders had, two of the founders had before the First Amendment was ratified. And they talked about their question about whether the First Amendment would just then make anything publishable without any sort of liability. And two of the founders, John Adams and William Cushing, had this discussion because what they were really interested in protecting was what they called instances of male conduct. And what that was extramarital affairs and those sorts of things. And they were really worried that if the First Amendment came to be, that newspapers would be able to publish instances of male conduct. And so they had this discussion and they came to the conclusion together that no, in fact, even though the First Amendment existed, that newspapers could still be liable for publishing instances of male conduct. So that was one of the really fun things that I recognized. And I think it's especially important in a Dobbs world where we care very deeply about historical relevance. And these tidbits in history then can lead to privacy protection, I think, in important ways today. So that's number one. And the second one is that Louis Brandeis is, of course, thought to be one of the people, and he, of course, who was most important for privacy in the United States. He wrote The Right to Privacy. He served on the Supreme Court. When I say he wrote The Right to Privacy, I mean the Harvard Law Review article published in 1890. And no one really knew about his background much. But what I found, and I think I'm one of the first, if not the first, to realize this, even though there's been a lot written about Brandeis, is that he represented a publisher in the mid 1880s and argued that that what the book was about was it was written by a school teacher who went to a small town on Cape Cod and recorded all of her interactions with the people there, with the students there, and then put that into a book that she called a novel. But she used the people's actual names, the actual circumstances, and it was basically like the days of reality TV.
Yeah.
Brandeis, who writes The Right to Privacy and cares about privacy very deeply, ultimately represents the publisher in that case. And intriguingly, his argument is in the case, this is an invasion of privacy. However, there's no law that supports it. And so therefore, the plaintiffs can't win. And so it's this really interesting story and important background regarding Brandeis, but my book was one of the first, if not the first, to report that.
It was really, really fast. Just all of that was very fascinating. And Misty, you know, if you have a quick nugget of trivia that you really, your brain really hooked on, I'd love to hear that too.
Yeah, well, first of all, Amy, the book was just, it was actually very juicy for nonfiction, I wanted to say. It's a really fun read.
Oh, thank you.
And it's actually, and so to the fact that you mentioned the instances of male conduct is so ironic that in today's world, we hear constantly about extramarital affairs and things of that nature. So the pendulum has really swung from or maybe eroded from the founding fathers' original intent with respect to the First Amendment. But for me in the book, I thought one of the most interesting passages was about the relationship between Grover Cleveland and Kate Nash. And that you made reference to the fact that it appeared that some dates had been altered in their correspondence. And for those of you who haven't read the book or maybe don't know the story, it appears that Kate Nash was maybe a paramour of Grover Cleveland and potentially while he was in office. And I just wondered, I wasn't able to tell from the end notes how you were able to determine that some of the dates may have been altered. Could you share a little bit about your research there?
Sure. And the important thing here was that Grover Cleveland was really good friends with Sam Warren, who was the co-author with Louis Brandeis of this Harvard Law Review article titled "The Right to Privacy." So he made all sorts of impassioned pleas for privacy as president, when he was president, because he married ultimately a young woman who was in effect his adoptive daughter, and so he had a lot of reasons to want privacy, and I guess that's probably one of those juicy stories. After he got married, he corresponded with a woman named Kate Nash. And so it's intriguing to think, because it was obviously some sort of love relationship, reading the letters themselves. And so that's a real reason why he would want privacy as president. And the way I figured out that some of the dates were altered is it was a really wonderful story. A lot of the research for the book involved me going to these libraries that had a lot of the actual papers. So historical societies, libraries that collected the actual papers, and the actual paper, the actual letter that Grover Cleveland wrote to Kate Nash is at the New York Public Library in one of the historical reference rooms. And so you have to request those letters, and you can actually touch the letter that Grover Cleveland wrote to Kate Nash. Wow. And so that's how it's pretty clear to me, as being someone who actually touched those letters, that the dates had been altered. So I actually literally touched those letters.
Who do you, of course we don't know, or I assume we don't know, but who do you suspect maybe altered the dates of the letters?
So some people think that many of those letters were written before Cleveland's marriage. That was sort of the important question was, were these letters, these love letters, written before or after he married? And the dates appear to be altered, suggesting through the alteration that it was after the marriage. And so what the theory was that whoever altered the dates did so to try to blackmail Cleveland or embarrass him or something like that. But it's not clear to me. And in other words, in doing the research for the book, some things are mentioned in those letters that suggest he is married at the time he writes them. So I was able to sort of coordinate some of the dates and figure out what he was doing on particular dates. And at least a couple of the letters then were in fact written, it seems to me, when he was president. So again, adding to the juiciness, also adding to the reasons why he would want then this right to privacy that he would obviously discuss with his good friend Sam Warren, who's then the man who went out and co-authored the right to privacy with Louis Brandeis, his law partner at the time.
Well, it's all, like you said, very fascinating, lots of juicy stuff. It's like the Real Housewives, but the real founding fathers instead. I think it's equally as gossipy. So, which, I mean, guilty pleasure, I do enjoy sometimes. So,
but important in law too, because
right,
these are the people
exactly.
who really laid the foundation for privacy law in the United States, and they had things they wanted to protect. They believed that they had the right to keep certain things from the public. And so it's deeply intriguing in that sense too.
Right. Yeah. And I think we often think of, right of privacy, freedom of the press, we think of these as very like static, dry things, but I think your book did a very good job of showing that in the beginning, it was a concept that wasn't fully formed. It wasn't even, according to Brandeis, representing that publisher, not even an actual legal right. And then also the right of the press was kind of, that's another nugget in your book of, what is it really? They kind of threw it in there, but they didn't really have a good concept, the founding fathers, of what that right really entailed, combined with the fact that the press was fairly new, to society. If we think about it, it wasn't something that was established and had been around for a while. So there are these concepts that were being formed, and there was a growing audience of people who could read at that time and reading that. So all that was very surprising to me. Do you find that surprising, to your audiences said the same thing? Or am I the only one who just didn't know this stuff?
No, it's definitely something that people have asked me about. And I think and asked me about for a lot of years now. One of the reasons why I wrote this book, in fact, because I think we grow up hearing an awful lot about freedom of the press and freedom of speech. And so a lot of people believe that there really is no right to privacy, that anything truthful, of course, should be protected and is protected in law. And that's very wrong. And it's been wrong from even before we had the United States, when government shut down presses for reporting the King of France's affair with his daughter-in-law. And so, we had this sort of balance between privacy interests, like instances of male conduct, and then, of course, the freedom of the press that the founders argued so much for, but also absolutely believed should be capped at a certain point. So really, one of the reasons why I wrote the book was to tell people about this rich history of the right to privacy in the United States. It's not just, and never has been just, press freedom and speech freedom. It's also protection of private information, sometimes perhaps too much protection if the politicians had their way, and then certainly I would say too little protection then as media then grew.
Yeah, and I think you phrase it as a romantic view of freedom of the press and freedom of speech, and I think that really kind of stuck in my brain, because people do talk about it in a colloquial way, but it's not a true representation of what those rights entail. So it's a really good, your book did a great job of reinforcing that, for myself. So,
Thank you.
let's talk about Hamilton again. I just think, is a great parallel between, the popularity of that book, of that play. And then also I think your book, again, it brings like realness to these people who weren't just some mythical beings. They did have their weaknesses. They did have their dirty laundry that they wanted to protect. And there were, obvious leaders in that, at the age of our founding fathers on to Brandeis and Warren, who were really compelled to align their personal views to the concept of the right to privacy and the freedom of the press. And so do you think, but at the same time, newspapers were publishing things, or publishers were publishing things that people were interested in. People were actually, wanting to read the information. So if we think of our rights as reflective of the norms of that time, is that really true, or is it really more of a, good for thee and not for me type of a situation? What are your thoughts on that, Amy?
So there was a real struggle at the time between these freedoms to reveal certain things, and I think that Jefferson is a really good example of this. So a lot of journalists have, quote from Jefferson in their office about the importance of freedom of the press. But at the time, Jefferson, a lot of people in Charlottesville and beyond knew that Jefferson was in a relationship with a woman he had enslaved. And that information was revealed by certain newspapers. And he didn't want that. And so what he suggested at the time was that the law should come down hard on those newspapers. And if they took those newspapers, they took one of the editors and brought charges against him, that all editors would learn what was appropriate and what wasn't. And so one of the people who had reported information about Jefferson's behavior was then that the charges were brought against that editor in Pennsylvania. And Jefferson allowed this to continue. So it's not like Jefferson said, don't bring those charges. Jefferson was the one who had encouraged that. And his interest was very much in keeping certain things private or secret. Hamilton, intriguingly, then goes on to represent one of these newspaper publishers in a, I think, pretty important case from the very beginning of the 1800s. And Hamilton makes the argument that certain information should in fact be published and be protected, and that would include Jefferson's behavior in the White House with regard to his governmental decisions. But Hamilton argues on behalf of the publisher that some things are off limits, including this sort of the notion of sexual impropriety. And I think because Hamilton himself had been embarrassed in this way. And so we have two of the founding fathers, the founders, making this argument for privacy on both sides. And so this very early case, then, in this very early case, the editor goes off to jail for a time and has to pay a fine as well. So I think what that story shows is just that the powerful, especially at the very beginning, were very protective of their own privacy, and that really laid the foundation then for our right to privacy today, including this relationship that Sam Warren had with Grover Cleveland. A lot of people think that and they're right, that law review article really came to be critically important, laying the groundwork for the right to privacy. Certainly that's correct. But it's interesting to go back and take a look at that relationship that Sam Warren had with Grover Cleveland. And one of the reasons why Sam Warren wanted great privacy too was because he was a millionaire. There was some interest in his family, media interest at the time, but then also he had married the Secretary of State's daughter. And so he became a celebrity of the day through his marriage into that family. And he and his family then suffered some deeply intrusive reporting about some sad things like family members dying. And so he had a lot of really good reasons to write this article as well, to protect his family, but also to protect his buddy Grover Cleveland.
Well, and I think, we talk about that article, that Harvard Law Review article, and I think it would be remiss for us to not talk about, the Harvard Law Review, of course, is very, very well thought of today. But when that article was published at that time, there weren't many law review publications out there, right? So it was very, very early on. And your book did a really good job, again, of highlighting that and also talking about how, I believe it was Brandeis was very central in forming a Harvard Law Alumni Association. Like he helped form it and get the membership out there, and then got that publication and sent it out to all the members, the Harvard Law Review itself, but also, the issue that had that publication. So there were a lot of future leaders of the legal profession out there that were getting that like spoon fed to them in a way. So there nearly level of engineering going on also with, certain cases that he was trying to get up to SCOTUS, I believe. So that was all, it wasn't just something that happened organically. It was like a very planned strategic move by some of these people. Isn't that right?
It is sort of, it is interesting. And certainly scholars do that today too. I mean, a lot of scholars will send their law review articles out in the hopes that maybe it'll get noticed. It is interesting though to think about Brandeis as being someone who was really very much promoting the article, not only to his fellow alums, certainly some judges as well, but also to the students who were working on the Harvard Law Review at the time. The Harvard Law Review was a very new publication, and Brandeis was one of the people who promised these students some additional articles. So he and Warren had written a couple of articles before they wrote to the right to privacy. At that point, once they write the right to privacy, their careers, or really Brandeis's career, takes off, and he never again writes an article for the Harvard Law Review. That was the end, but of course, such an important end.
It was his swan song, I guess, for the Harvard Law Review.
Yeah, sort of, kind of, but
a little bit.
Such a great legacy. Yeah.
Right. So, again, something that was apparent from your book was the introduction of, in a way, new technology. And this doesn't seem like technology now, but the addition of just illustrations in publication was a driving force in conversations about the right to privacy. And we're talking about, making sure people are represented with dignity and things like that. So, for me, looking back and thinking an illustration, how can that be so transformative? But now we're also talking about things, Missy and I, Missy, I'm going to ask you about this next, about like the metaverse and impact, like how that could potentially, transform our current dialogue of privacy. It seems to be not only do individuals have an impact on driving on, where we as a society want to be, but also the technology transforming what is out there to the public to see versus private. Would you agree with that, Amy?
I sure would. It's interesting to take a look at the outrage when newspapers and other publications of the day had the technology that it allowed them to include sketches of people. So literally like, woodcuts of people that were later then included in newspapers. I mean, people were horrified, especially leaders, because they ended up looking pretty bad in these sketches, meaning like literally they didn't look handsome.
Right.
Yeah.
And sometimes just the artist wasn't a good art, it's wood cutting. So like how delicate and reserved is someone going to look when someone's just like, making a wood cutting.
Exactly.
So.
And one of the prosecutors in New York actually came to a newspaper in New York and said, you know what, you're using these images of women and you're using images of women and they're not looking good. We're thinking about bringing criminal charges against you. So, I mean, it was that sort of outrage at the time, sort of like some people feel today, that they don't necessarily want to have their picture taken, or they, regret, having their picture taken in that way. Well, they felt the same way back then about these woodcuts and other sorts of technology.
So this brings to mind, a common theme throughout the book and throughout issues that are raised that you highlight. It's being protective of women, like the women, the image of the women in the illustrations, the images of women being used in advertising, later on. Is that really just a guise for certain people to get the rights that they want, or does that again really match the norms of that time? Were you able to tell from your research? I know you can't go back in time, obviously.
Yeah, I mean, I do think that there was this sense that women needed to be protected in that way, but women needed to be protected in that way, but ultimately the real interest, those were sort of asides. I think that the real driving force ultimately was protection of the powerful, and the suggestion that certain experiences, truths from the powerful's lives should be protected, should be kept from readers. And so if you look at those early cases involving women in literally featured in ads, they would use language like, women need to be protected in this way, that sort of language. And that's the basis certainly for the same rights that we have today. But I think that the real impetus again was protection of the powerful.
Well, it's interesting. It's interesting too, because I think in that particular, one of the examples that you have in your book is the young woman whose likeness was put on the flour bag. And so her likeness was being used to sell this flour. And so I think there was some indication, I guess, that she was embarrassed, or her family was embarrassed that her likeness was being used in that way, to sell the flour product. And so, but it does make you think nowadays. I think the people are concerned about their likeness being used from, say, like a copyright type infringement. I'm thinking of in the news lately, you hear about whether athletes should be, student athletes, college athletes should be compensated for the use of their likenesses in certain scenarios. And it's not really a privacy issue; it's privacy adjacent, I'd say. But do you also feel that there's some sort of a tide turning in that way, from the way that the use of likenesses were used and perceived in those days versus how they are now?
So I don't really think so. I think because one of the things after that case, the flour case, was decided, and what ultimately happened in that case was that the High Court of New York said, listen, girl, because she was 17 at the time. Listen, girl, you should feel honored that you were found pretty enough to be featured on in this ad for flour. Therefore, you have no legal right here, no legal claim. That's what the High Court of New York decided. That outraged a lot of people and a lot of legislatures. And so almost immediately then, legislatures in the United States and courts began embracing that sort of what they called the right to privacy. That was, by the way, one of the arguments in the right to privacy, inspired in the right to privacy article by Mrs. Grover Cleveland and the misuse at the time of her image in advertising. Right. So therefore, there's that foundation for the use without permission of people's images in advertising. That was one of the very, very beginnings of a court's embrace of privacy. And that has continued through today. Today in the second restatement, which is the most recent restatement, misappropriation exists, and that's precisely what it is. And from there, we build then statutorily with the right to publicity, and from there, then these rights of student athletes and otherwise. So it is a super interesting time to think about those things.
Well, and again, talking about transformation via technology, even looking ahead to use of likeness after death. I know that Robin Williams, in his wills and trust, he put limitations on how his likeness would be used in like holographic or virtual space, because he was a gamer and he had the foresight to go, my image could be used in a way that's not common now, but it could be more common. And I want to protect that. So, I mean, Misty or Amy, do you see that becoming a more driving focus now that we're talking about augmented reality, mixed reality, virtual reality in the context of the metaverse? Maybe not. Maybe it is going to be.
I can especially see it of course, in the context of celebrity, right? Because, the estates also might have some interest in making sure that the likeness is not being used for purposes that might be generating money, where the estate is not getting some sort of compensation for that. I wonder whether that will become more commonplace for people who are just, the average Joe like me, and whether that would be something that I would want to protect my my persona after my demise. Will that be something that I'll need to worry about or care about? It's a really interesting question, but certainly we're headed toward augmented reality, and we're already there. So
right, especially I know there are AI related companies in the news lately about they've potentially allegedly scraped images online to help train their system. So how would we feel if an image of us is used as a virtual assistant, which could potentially happen? So I think that's a very, transformative direction right of privacy may go. Don't you think, Amy?
I sure do think so. And one of the, sort of thinking about a parallel, when at least early on, when people would post images without restriction. So allowing anyone to use a photograph that they'd taken without restriction. The problem was that there were people in those photographs as well. And so if there were a company that wanted to use that photograph, and this happened, they would believe that they had the right to use the photograph because there was no copyright issue within the photograph. The photographer had given it to them to use freely, but the use of the person inside that picture, then that person had rights as well. And so those people would bring misappropriation, right to publicity causes of action. And so you can imagine, that there would be companies, just like there were before we understood that would indeed scrape these images of real people and use those real images, just like they did at the very beginning when we didn't really understand Creative Commons and those sorts of rights.
Mm-hmm.
I mean, just based on that story, I think that you might imagine companies trying to look for the perfect person to fit a particular role in a video game or otherwise, and finding real people to use in that way.
Yeah. Like we were saying before we kicked off the session, it's an interesting time to be an attorney, I think, or a practitioner of cybersecurity as well. So, you know, I want to just move towards the right of the press a little bit, which I know is a direction that your book goes to. You know, the right of the press. You know, again, this book really shows the balance that happens between the right to privacy and freedom of the press. And we saw in, you know, from the 1800s to the early 1900s, some stress there. And then it seems like we started seeing more regulation by the press via, you know, code of ethics, you know, potentially influenced by Harding's Be Decent edict. You know, do you think that, and a lot of those are about, you know, the person's right to dignity, and there's a lot of element of thoughtfulness towards the individual and what you publish, but that's a very fact intensive analysis. So I would imagine that there could be the potential for a lot of variances in the courts during this time as to what's in violation and what's not. You know, is that something that you were able to pick up on in your research?
Yeah, for sure. There were, what I'll do is I'll sort of explain the arc and then give you, I think, a really good example of how much variance there can be in such cases. So at the very beginning, there was the right to privacy is growing, right? The early 1900s, the right to privacy law review article has been written, privacy is growing. And then right in the 1920s, newspapers, publishers of the day, started embracing ethics codes. And one of the parts of the ethics code for journalists was protection of privacy, individual privacy. So as journalists and other publishers began embracing ethics, courts began to trust them more. And so from the 1930s until, you know, the 1980s or so, maybe early 90s, publishers routinely won invasion of privacy cases because courts said, who are we to second guess what publishers are doing? We are not journalists. We trust them to decide what is news and what isn't. And so we go from this time of, you know, real protection for privacy into this celebration of press freedom. Now we've shifted more, again, back into privacy because of growth in technology and what's being done. But getting back to your question about this, the variance in decisions, I think one of the intriguing ones to think about, and again, I like to think about gender in these cases too, but one of the intriguing examples is a case from the 1960s that extended beyond, and that was involving a documentary called Titicut Follies. And in Titicut Follies, they allowed a documentary producer, a photographer, to go into a videographer, filmmaker, to go into a prison for what they called the criminally insane in the Boston area. He recorded an awful lot of imagery of these prisoners being mistreated. Some of them were nude. And so the guards at the time brought an invasion of privacy case against the filmmaker, arguing that these prisoners had rights. The right to privacy, but really the whole film was about the guards and their behavior and how they mistreated the prisoners and such. A court decided that documentary should never be seen, and so ordered the filmmaker to destroy the documentary, destroy the footage. Ultimately, that was overturned to some extent. A higher court decided that indeed the film could be seen, but only by law students, lawyers who worked in the area. So very narrow, a very narrow allowance for viewing of the documentary. And that lasted until the 1990s. So
well,
restriction on that documentary on privacy grounds then lasts until the 1990s.
Well, and some of that, well, first of all, I have two questions, one question and one comment. One question is, did you end up watching it as an attorney, or were you able to go watch it?
So yeah, because it's been lifted now. The restriction has been lifted. And so one of the things that I've done in my privacy class since I started teaching this more than 20 years ago is I like to show the students the documentary, and I like to talk about these individual issues. So now it's open for everyone to see. You can watch Titicut Follies and see the mistreatment that I'm talking about. And so it's interesting to see that film and think that somebody, a judge literally decided that we really shouldn't see it unless we're involved with helping prisoners in some way or otherwise.
Right. And one thing that led to that ban being lifted was those prisoners are probably no longer alive now, right? Or didn't that have some impact too? Like there's not the personal dignity argument to be personal right to privacy at stake anymore because they're not alive anymore.
That's right. That's right. And one of the key people featured in the documentary was writing a book. And so he decided that he was okay with his image being used in that way. And I'll just mention very quickly another case that sort of butts up against that. So that continues throughout the 1980s into the 1990s. Right around that time, there was a TV news station in Oklahoma that got video of a woman being raped. And that TV station then decided to publish parts of that rape. Nothing showing any what we would call private parts, no genitalia, anything like that, but his legs moving on her legs, and used it as part of a news story to show that this person had in fact raped women, and then took video of it. And so she then brings a right to privacy claim against the TV station, and the court decides that she loses, that this was important news, that the TV station had decided it was newsworthy, and who was the court to second guess that decision. So it sort of shows just how the variance then in ways of balancing, I guess, this right to privacy with press freedom.
Well, and I know, talking about, the documentary being released, we're getting closer to a more modern age. And I'd like, Misty, for you to talk about, or would like your thoughts on, this is when we're seeing the birth of the internet come forth. We're seeing reality TV. We're seeing 24-hour news channels. We're seeing cable channels, some more content out there. And, how did these technologies, these maybe transformative technologies, were they driving forces of what would eventually lead to, privacy laws that we're seeing today, or what sort of impact did those potentially have on current day privacy laws?
Yeah, I think they absolutely did, because we have a new medium that is completely different than anything that we had before. And I'm not a scholar on Section 230 of the Communications Decency Act. Amy is. So I would welcome her input into this as well. But if for those of you who remember back in the 90s when President Clinton was in office, there was quite a bit of concern about pornography, the rise of pornography on the burgeoning internet, and protecting people from viewing, from stumbling across pornography and things like that. But then also there was concern on the part of the website operators that, we can't help what other people post. If any of you are old enough to remember AOL and like AOL chat and things like that, those operators were very concerned about, well, if people are using our website to communicate and they can, post messages or send messages to each other, we can't watch all of that. And so there was a great concern in the balance between the website operators being able to operate their business and a safe way, and also to protect the rights of the individuals and their freedom of speech and what they can say on those websites. And so the Communications Decency Act was enacted in the 90s, and that it's still very significant today. There are a couple of Supreme Court cases that are raising issues about Section 230 in the context of terrorist groups, basically, that were posting on websites, and whether those websites should have done something to tamp down the terroristic messages that were on those websites. And so they're still relevant today, these laws that were put into place. And of course, building on the privacy laws that we already had in place, and the procession of privacy, as we have been talking about today. But Amy, if you have further insight into Section 230, I don't practice in that area. I'm just aware of it generally, but.
I think that it's one of the reasons why we have this real shift toward privacy today, why courts are embracing privacy all the more, because what happened was, at least initially, right, the New York Times then is not liable for letters or for comments on news stories. Reddit's not liable for comments posted there. But what happened is some websites then took advantage of this and began to post what some people call revenge porn. And in those circumstances, then the website would not be liable because of Section 230. The poster would be, but the website itself would not be. And so that's the reason why then suddenly judges said, like, what is going on the internet? We need to protect people, and why now there are so many calls from both sides of the aisle to amend Section 230. So, and it'll be interesting to see what happens at the Supreme Court as well, when that case is heard and then decided in just a bit.
Well, I'm going to go back to SCOTUS, but I have another question for you, Misty. I know when I think of data privacy a lot, I think of data breaches and PII. And, when I look at the information about individuals in a data breach, it's a fairly sterile, point of data compared to maybe an illustration or an incendiary story of someone's sex life. And yet there's a lot of scrutiny and a lot of drive to, address these issues and protect the rights of people when their PII or PHI has been breached. So do you think it really just comes down to financial impact versus dignity/embarrassment, or do you have any thoughts on that?
I would have thought that before I got involved in data privacy practice, because certainly financial information being breached can be harmful to an individual because of identity theft and fraud that could be committed against that individual. It takes a lot of effort and time to undo identity theft and fraud and things like that. If say your social is used by a bad actor, certainly the financial aspect is bad. But as my practice has broadened, and now I represent a lot of healthcare clients, you'd be surprised how upset people are by the breach of their protected health information. It's interesting because there's not much that a bad actor could do with that health information, really, because just if somebody knows what doctor I go to, if they go to my doctor and try to use my healthcare information, they're not going to be able to use it probably. But it's the dignity of the individual. They may have some sensitive health diseases, or just something very private that they're sharing with their healthcare provider. And so I would say that those breaches are actually a little more maybe newsworthy at this point, because people are extremely focused on their protected health information. So I would say it's both.
That makes sense. it's very easy to look at the financial aspect of it, but I can definitely see how PHI would, while there's not an obvious direct line of someone making money, especially off of the more, elusive things, not your social security number or whatever. But I can see that being, more alarming to people. So
can I just break in for a moment here? I think it's what I find fascinating about what you just said also was thinking about that in terms of data brokers and how data brokers could in fact perhaps equate, right, a doctor's name with a certain diagnosis, and therefore, allowing that information out there to have data brokers make use of it is why we have, I think, a lot of this data privacy legislation today being pushed by legislatures. And then the other two, just really quick, as you were speaking, I was thinking two very quick cases. Number one, there was a case decided by the Seventh Circuit a number of years ago where there was a request for abortion records that were scrubbed of any identity, allegedly, of the individual. And the Seventh Circuit decided there would still be privacy in that health information, even though it had been scrubbed of any sort of identity. The court said, having that sort of medical information out there, even if it wasn't by name, would really feels like a privacy invasion. So this area, I think, is a particular interest now, especially in a post-Dobbs world.
Right. Well, and so OCR, which is the Office of Civil Rights of the Department of Health and Human Services, just in the last month or so, maybe 6 weeks, came out with guidance about pixels that are embedded on healthcare provider websites. And OCR has now taken the position that if you have a pixel on your website and someone can go and say you're searching for a doctor in your area, so you have to put in like what type of doctor you're looking for, a neurologist in my zip code 30324, that in some instances that can be protected health information. And if you're passing that information to say Facebook Meta or to Google, that can actually be a breach under HIPAA. And so it's an extremely hot topic right now. We could talk for a whole hour just about pixel technology, because that is a huge focus of the regulators right now. And I suspect that we'll be seeing a lot more of that in the future. And OCR has been very aggressive in pursuing healthcare providers that are not disclosing pixel usage on their website, or perhaps have pixels embedded on pages of their website that might pass protected health information back to the third-party service providers like Facebook, Meta, or Google. So it's just a really interesting topic.
Wow, that's really interesting.
I feel like we could talk for another hour or two. But we are at the end, and I have one very short question for you, Amy. If Brandeis were to read your book, would he want you to go to jail for that book?
So I don't think so, because what I really tried to do in the book was with Brandeis at least, what I really tried to do was protect people. So you'll see that I do use a lot of recent stories, but I don't name names in those stories because they're important stories, but I really try not to reveal the identity of certain people. So I think that Brandeis would be on my side.
He would be okay with you? Okay.
Yeah.
All right. Did you think about that at all while you were writing? Did you have like Brandeis over your shoulder a little bit?
Yeah, but also I think it's my journalism training. So just when I was a journalist, just working with ethics, journalism ethics, and what I learned and what I didn't report. And so it was that sort of guidance, in addition to knowing that this book would then promote Brandeis's ideals as well.
Well, with that, I want to say thank you to you both, Amy and Misty, for joining us. Like I said, we could talk forever, but I do know that you're all busy and it's a Friday afternoon. So I hope you have a wonderful weekend, and hopefully we can get together and talk again about all this fun stuff. So
it'd be great. Thanks again to everybody for joining. Really appreciate it.
And get the book. It's great. It's a great book. So
thanks so much.
Bye. Thanks for joining, everyone.
Bye.
Thank you all.